My name is Ed Hicks. I'm a barrister at Radcliffe Chambers, for those of you who don't know me. I have a mixed practice of property and private client, and this talk is very much aimed at the property side of my practice and arises out of a case which I'll explain a little bit about that I did last year. Nothing that's been reported, but it raised some interesting questions of law. So without further ado, what is adverse, what are encroachments, and how, what have they got to do with adverse possession? Well, the summary in Jordan on adverse possession is pretty much as I've set out on the screen. The tenant B takes possession of his landlord's A's land, not included in the demise, by virtue of his possession of the demised premises. So the landlord has to retain land, the tenant goes onto it and takes possession. And the doctrine says that the land is presumed to be in addition to the demise and must be given up at the determination of the lease, unless B's conduct makes it clear that he's occupied the land for his own benefit and not as part of the demised premises. And the second way in which the doctrine applies is in dealing with third-party land. So the tenant B takes possession of the land belonging to a third party C, and then both B and A can contend that the land has been added to the demise under the lease. So that on expiry, it must be given up to A, the landlord. So the landlord effectively benefits from the tenant's occupation. Now, just to give you a visual representation of that, if we have A, the freeholder of the blue land, B having a lease here of the from A of the land edged red, and C being the freeholder of the yellow land. So in the first instance, let's see if the graphics work. Yes, so there we have the leaseholder taking possession of C's land. That's one of the situations which can arise, or here we have the leaseholder taking possession of A's land. So that's the visual representation of what's going on. I suppose that there's a thought that may occur to you, which is, well, why does this matter? Isn't this all just part of the law of adverse possession? Aren't we all now pretty much in registered land, and isn't it jolly difficult to claim a title by adverse possession under the Land Registration Act 2002 against registered land? So does this really matter? And there may well be something in that view, and in fact it's the view I kind of took when I started looking at this, that this is all really a storm in a teacup, but it's never quite so simple. There are circumstances in which this doctrine may take particular importance, and I've encountered this a couple of times. Once in a case I did involving a loft conversion, where the tenants under a long lease in a very expensive London townhouse had developed up into the loft. One of the questions when the landlord, who was pretty much a paper title only, had bought the freehold for about £2,000, if that, then tried to claim possession and sue for trespass in relation to the loft conversion. So one of the arguments we deployed was that we've added it to the lease by adverse possession. So it does arise in those circumstances. And the case I was involved in last year, called Giorgio and Wong, as I say, it's not reported, it's a county court authority. In that case, what had happened was the tenant had a first floor flat, and had to the rear of that flat was an area of flat roof. So looking out of your back window, as it were, you look over this area of flat roof, which was above the part of the landlord's retained land. And they rather like the look of this bit of flat roof, knocked a hole in the wall, put in a door, and then erected a roof terrace, which they then proceeded to use for a very lengthy period of time until the landlord finally got round to dealing with it. And in the course of that case, now I should say in that case it was a cynical land grab. In the course of that case, they tried to argue that notwithstanding we were dealing with registered land, and this was, say, last year, and the relevant period ended in a couple of years previously, the relevant period of adverse possession, if indeed it is adverse possession. In that case, they knew perfectly well what they were doing. They knew perfectly well it wasn't within their demise, but nonetheless tried to claim under the Limitation Act 1980, despite the fact that it was registered land, and the legislation says that the Limitation Act 1980 doesn't apply in those circumstances, in order to give them a title. So these arguments do still crop up, especially in areas in which you've got particularly converted buildings, where it may not necessarily be obvious exactly what the scope of someone's demise is. And there may be bits of land here and there, roof terraces, lofts, gardens, and so on, where you might actually be able to try to seize something as a tenant against the landlord. Now, again, it is rather an odd doctrine. The tenant's demise is going to be defined by their lease. When one looks at that original definition, we saw it from Jordan. I mean, why is it that the tenant, just because they go on someone else's land, the landlord's land or a third party's land, acquires a right? Aren't they simply a trespasser? Well, the answer is yes, of course they're a trespasser. And so why can't the landlord bring a claim to get rid of them? Well, the answer is maybe he can. And so the doctrine is not quite as simple as looking at the tenant's position. One also has to look at the landlord's position. When are the landlord's rights barred, if ever? So is this a doctrine that grants the tenant rights against the landlord? Or does it do something else? Does it in fact limit the rights of the tenant that he might otherwise have against the landlord? And if so, when? And I think the really helpful way to look at this and to untangle what is a tangled knot of case law that doesn't make a huge amount of sense and the origin of which is unclear, is to try to split this up and look at this from two perspectives. And in the first instance, I look at the tenant's perspective. Here you have a tenant on someone else's land. Are they in a position where they can ever stand up and say, well, this is mine, landlord, I'm taking it free of the lease? Or are they, if they're in there, are they stuck with the position that it's part of the tenancy, part of the lease? For example, at the end of the tenancy, can they turn around and say, well, it's not within the tenancy, it's not within my repairing covenants, for example? And the other perspective is that of the landlord. Here is a landlord, there's a tenant on his land. Is he bound to accept the tenant? Is he bound to accept that the tenant has the encroached upon land as part of his lease? If so, why and when? And I think it's helpful just to draw that distinction between the two, because the cases tend to look at one or other of the perspectives without necessarily drawing that distinction, and that can lead to confusion. But before we get into the law of encroachment, I think it's just helpful to have a little recap of a few basic principles, because these will crop up in the course of the analysis. Adverse possession under the Limitation Act 1980 is pretty clear. Section 15, there's no right of action after 12 years from the accrual of the right, which essentially accrues under Schedule 1, Paragraph 8, when there's a tenant in adverse, when there's somebody rather in adverse possession. That is somebody in whose favour possession can run. Obviously, if they're claiming under a lease or a license or have permission to be there, then it's not adverse. There's no claim the landlord could bring against in respect of which time could run. And it's also worth noting by Section 17, automatically on the determination of the limitation period, there's an extinction of the existing title. So the tenant goes in and then he takes effectively a freehold title, or at least a title free of the landlords. Adverse possession, just by way of brief recap, we're looking at factual possession, intent to possess for the time being, to the exclusion of others, including the owner with paper title, and that it must be adverse, as I say, that there's no sort of right to possession that would preclude the landlord from bringing a claim and starting time from running. And just briefly, in terms of registered land, by Section 96 of the LRA 2002, in respect of a registered estate, Limitation Act provisions are disapplied, at least as far as the relevant estates are concerned. There are some exceptions, we don't need to deal with them today. And then by Schedule 6, there is a specific statutory mechanism by which an occupier, adverse possessor who's been in adverse possession for 10 years can then apply to be registered, and there are various ways in which that can be disposed of. In essence, unless the tenant can come within 3 gateways, that there's an estoppel, some other reason why he should be registered as title, or an honest mistake as to the location of an undefined boundary, then the application is going to be rejected, and the tenant, the landlord, one assumes, will then evict the tenant. Although if the landlord doesn't do so and the tenant remains for another 2 years, giving him 12 years in total, then he can also be registered. And there's also a Section 98 defence. So this is if the landlord actually does bring the proceedings, the tenant has a defence if he can say, well, I would have been able to bring an application to be registered under Schedule 6. And I could show in particular that I'd have been entitled to be registered because of an honest mistake, or because I've been there 2 years after rejected application. And it's also worth looking very briefly at proprietary estoppel by acquiescence. People, I'm sure, will be familiar with the various probanda, as they are sometimes known. But essentially, when you're dealing with proprietary estoppel by acquiescence, we're looking at the person B adopting a particular course of action in relation to land, that B is mistaken as to their current rights in relation to that land, that A knows of B's belief and A's inconsistent rights, A fails to assert A's rights against B, and that B would suffer detriment if A were free to enforce their rights. In those circumstances, B will have a claim by proprietary estoppel of some description, which the court will then have to satisfy. They'll have an equity, which the court then needs to give effect to. But it is important to note the limits of that, and in particular per Lord Carnworth, the Vice-Chancellor in Ramsden and Dyson. He said this: it will be observed that to raise such an equity, two things are required. First, that the person expending the money supposes himself to be building on his own land. And secondly, that the real owner at the time of the expenditure knows the land belongs to him and not the person expending the money in the belief that he is the owner. For if a stranger builds on my land knowing it to be mine, there is no principle of equity which would prevent my claiming the land with the benefit of all the expenditure made on it. There will be nothing in my conduct, active or passive, making it inequitable in me to assert my legal rights. Now that is quite important, because merely standing by and doing nothing will only affect you if the person encroaching on the land is making a mistake as to the rights, and you know about it and you do nothing. Now this, as I say, is quite important. So in my land grab case, the Giorgio and Wong case, there couldn't be an estoppel on this basis because the tenant knew full well that the land was not included in their demise. And so the estoppel arguments only go so far. Of course, if there's some active conduct, or the conduct goes more beyond simply passively failing to assert rights, then that's slightly different. There may be an estoppel by representation through conduct, and that may have some relevance in some cases. But essentially, if you're dealing with simple acquiescence and standing by, estoppel may not help you. You're really then, in terms of the tenant or the encroacher obtaining rights, you're then really in the realms of adverse possession. It's worth just briefly noting a few of the three-party cases. So this is where there's an encroachment on the third party's land. I've given you a few of the head note, the relevant cases here. We won't look at all of them. But I think the trouble in some of these cases is that there really is adverse possession. It really is part of the law of adverse possession, because of course the tenant, in order to get anything at all, any right at all, has to adversely possess the third party's land. And then at the end of that period, when the tenant has acquired that land by adverse possession, acquired the right against C, then there's the debate about the position between A and B, the tenant and the landlord. And the cases tend to arise at the end of the tenancy, where the landlord says, right, well, that's now my land, that's an accretion to my land, or it's the landlord making the claim against the third party. What these cases don't really explore, which I think is the more interesting question, is what's the position between the landlord and tenant during the currency of the lease. And that's really, I think, is where I'd like to focus today's analysis. This is, as I say, a huge topic, and we can't cover absolutely everything. As I say, that you need a claim for adverse possession, and typically the focus is going to be on whether that is actually made out. And if there is a debate between the landlord and tenant, it's likely to be whether the tenant is saying, well, I was occupying not for your benefit, landlord, but for my own. And that's the sort of thing that would crop up typically at the end of the lease. But in terms of the landlord's retained land, which is perhaps the more interesting development, Smirk and Lindell developments summarised it neatly when Pennyquick, the Vice-Chancellor, said the law on this point, if I may respectfully say so, has got into something of a tangle. I mean, that's a real understatement. And again, one sees a lot of the case law is focused at the end of the tenancy. End of tenancy cases focusing typically on the tenant's position. So is the tenant bound at the end of the tenancy to hand this property back? Now, either the doctrine applies, in which case the tenant will be obliged to give possession back to the landlord, one way or another. If he had acquired a right against the landlord, he'd be obliged to hand it back under the doctrine. And if he hadn't, I suppose he'd be a trespasser and would still have to hand it back to the landlord. The alternative is that the tenant can say, well, it doesn't apply at all, or I can rebut the presumption, and I can claim a good title against you, landlord. And that tends to be where the fight will be in those cases. Whether the landlord is bound to accept the tenant at some point during the tenancy is not really going to crop up. I suppose the only debate might be whether the landlord could maintain a claim in damages for trespass against the tenant. By way of an example, I'll just take you through a few of the cases as to how when we are looking at the position actually during the tenancy, how the courts have analysed that. Tabor and Godfrey, I'll just explain the case a little by reference to a diagram, which I've unfortunately it's not come up particularly well on the slides. But essentially there was a row of houses were developed, and behind the houses was a passageway, which I've shown here in yellow. And each of the houses, the idea was they each have a gate opening onto the passageway, which they could then use. And the property is the one shown in red for the purposes of this diagram, and that is how the leasehold plan was laid out. In fact, what was built at the time, because this was a developer case, what was built was this. So one could see the same row of houses, but in fact the properties, the middle properties, extended all the way to the rear. There was no passageway to the rear, and they opened onto two side passages, one going each way. And so, as you can see there, we have the red land being what was actually demised in the paper title, and the blue land behind it is the strip, which was the encroachment. And that was the position for more than 12 years, which was the statutory limitation period at the time. And the landlord turned round sometime later and said to the tenant, well, that's you're trespassing on my land. And the tenant defended the action, said, no, that's not the case. Now, the case can be explained possibly as under the statute of limitations. It could be said, well, here's the tenant, they've been in adverse possession of the strip for more than 12 years, and therefore one can analyse it as an adverse possession case. They should have title, but the presumption then applies to restrict them from relying on the statute to the full extent in some way, and limits them to an accretion to their tenancy. But in fact, and that was recognised by the court, but in fact what the court held was that this was nothing to do with the statutory limitations at all. And what was said was that both parties from the outset had treated this land as part and parcel of the demise. It's been marketed on that basis, the tenant had accepted the lease on that basis, and really in those circumstances one couldn't go back and having proceeded on that common basis, one couldn't go back and say, actually, it's still my land. This is a classic proprietary estoppel case, as it would now be analysed. And the trouble is, Tabor and Godfrey forms a lot of the basis for a lot of the subsequent case law. As I say, it can be explained on either analysis, and really that what the court was saying was this is an estoppel, nothing to do with limitation, and therefore nothing to do with adverse possession. Perrott and Cohen is worth just considering briefly. In Perrott and Cohen, the tenant had taken a lease of some land from the landlord and had realised that there was some adjacent lavatories, which they decided, which weren't within the demise, but they decided pretty much from the outset to start using, and did use. The landlord spotted this, and I think one solicitor's letter was written complaining about this, but nothing was actually done until the end of the lease. And at the end of the lease, the landlord turned around and said, right, tenant, you've got to pay, you've got a repairing covenant, you've got to pay for the enjoyment you've had of these lavatories as part and parcel of the tenancy. You've got to actually fulfill your repairing obligations. And the interesting thing about that case was that the time period, the time of the term was 12 years less 1 day. So of course that is 1 day less than the limitation period. So the case cannot be explained on the basis of adverse possession and limitation. The limitation period hadn't expired. But essentially, the point was that the tenant had gone in, claimed it as though it was part and parcel of its tenancy, and couldn't go back on that, irrespective of the fact that the landlord hadn't really done anything at all. The tenant was stuck with it, and essentially had to then pay the repairing covenant applied. So that really does look at it from the tenant's perspective. It doesn't really look at it from the landlord's perspective, save that the landlord was perfectly entitled to say, yeah, you know what, I accept that the tenant is in occupation of this land as an accretion to the tenancy, and I'm going to rely on that and take the benefit of it. Lord Justice Denning, as he then was, did say, obiter, that if a landlord should allow a tenant to occupy adjoining land and by his conduct represents to the tenant that it was included in the demise, and the tenant acts by using it as such, then the landlord would be bound. So that's very much an estoppel analysis, but as I say, didn't deal with adverse possession as such. Ali and London Borough of Tower and Hamlets is another case in which an estoppel analysis was applied. The period of time in that case wasn't long enough for an adverse possession claim to have run. But Smirke and Lindale development is worth a look, because this is a case that can't be explained on an estoppel basis. Hopefully everyone can see this diagram. Essentially what was going on in this case was there was a row of houses and various land behind them that was owned by the British Railway Board. And service occupancy tenancies were being granted, and the tenant in this case took a lease of number 191. Behind the 191, and that was in 1955, behind 191 was a path, and then there were two parcels known as the blue and the pink parcel, one behind his property and one behind the neighbouring property. And they were basically, I think they were old allotments that had been disused since the war. In 1960, he occupied the blue plot, cultivated it, and by 1960 it basically turned it over to a garden and closed it. And then later on, by 1966, he had done the same to the pink land. And then in 1973, the freehold had been sold off to developers. 1973, the developer comes along and says, right, well, I want to develop this land. And then there was a discussion essentially as to whether a title had been acquired as an accretion to the lease of either the blue or the pink plot. Now, the case was argued as a classic classic adverse possession claim. That is how it was advanced. Adverse possession subject to the presumption that the result be an accretion to the tenancy, not destruction of the landlord's title, and that the tenant would not acquire the freehold. And the claim, it failed at first instance because there was said to be an interruption to the tenancy, but that was overturned on an interruption to the period of occupation by reason of the tenancy determining and a new tenancy being granted. That was overturned on appeal. It was considered to be one continual tenancy. But for present purposes, the interesting point is that the claim would, and ultimately did succeed in relation to the blue land, but not the pink land. Now, there's no suggestion that the landlord that this was anything other than a land grab, essentially. The landlord hadn't made any representation, as in Tabor and Godfrey. This was anything to do with the land was anything to do with the demised premises, and had literally just stood by and done nothing. So it was a land grab by the tenant, but because 12 years was established in relation to the blue land, that's why that succeeded. The claim in relation to the pink land did not, and the only explanation for that is that 12 years adverse possession had not been established. And so this, as I say, this was a case that was argued on that basis and can only really be explained on the basis of adverse possession. So just pausing there, a possible explanation of the doctrine and its effect is this. The doctrine does not give the tenant any right against its landlord per se. What happens is that the tenant may acquire a right against the landlord from some other source, or it may be said that but for the presumption the tenant would acquire a right from another source. That could be proprietary estoppel. It could be adverse possession. It could be, I suppose, contract. or some agreement. But the doctrine operates to stop the tenant from asserting against the landlord any right that he holds the land other than an accretion to the tenancy, whether it could be said that but for the doctrine he would. So, but for the doctrine, I would have acquired a freehold by adverse possession. The doctrine restrains me from doing so and limits me to an accretion to the tenancy. Or indeed, that the tenant is stopped from saying that at all. In other words, at any time, the tenant cannot make that assertion. So, as in Perrott and Cohen, for example, the tenant hadn't acquired any right against the landlord had done nothing. But the tenant was still stuck with it. So, again, from the sort of separating out the landlord and tenant position, the tenant goes in and from day one is stuck with this restriction, this presumption. You go into the land as an accretion to your tenancy. The landlord wants to accept that and act on it. That's up to the landlord, and then the tenant, and at that stage, the landlord is stuck with it. But as far as the landlord is concerned, the landlord is not bound and could just evict the tenant until such time as the tenant has, or but for the doctrine, would otherwise acquire a right. And as we've seen in Smirke and Lindale, that in relation to the Blue Land, that was by adverse possession. In Tabor and Godfrey, and that could have been by estoppel or arguably adverse possession, but the analysis in the case was on the basis of an estoppel. Then we come to the most recent modern authority, which is a Hong Kong authority, the Secretary for Justice against Chow Kar-chit So, which was decided in 2013. Now, in this case, what had happened was various government lessees had I think been maintaining fish ponds on their land and had extended into some other government land for many, many years. The limitation period under the relevant ordinance, the Hong Kong ordinance, was 60 years against Crown Estate, but they'd been there for about 70 something. So a claim in adverse possession, but for the doctrine, would have worked under the relevant ordinance, which operated pretty much in the same way as the Limitation Act 1980 does in the UK. The provisions are basically operating in the same way. And the claim of the tenants to be entitled to an accretion to their tenancy succeeded, but there was two distinct views as to why it succeeded and how in practice the doctrine operated. And Lord Scott, giving the majority judgment, I've set out some of the comments he made here, regarded the tenant's position as that the doctrine is applying in a unilateral way. So the tenant, as the encroaching lessee, is bound from day one. That's the point I was just making. But it does not bind the landlord, the lessor, until he either accepts it or by the expiry of a limitation period, he becomes unable to recover possession and therefore forced to accept it. So he can evict. So from the landlord's perspective, he can evict the tenant up until the time at which he becomes bound. But what's the effect of all this? Well, what he held was that on the expiry of the limitation period, the encroacher would not be a trespasser and could resist an order for possession. They would, under the presumption, be entitled to treat the land as an accretion to their lease. But the statutory effect was restricted. The title of the government, the landlord in that case, was not destroyed. It would be an accretion to the lease. So that was part of the relevant ordinance, didn't apply. And what the landlord could do, and this is under another of the relevant principles, was that when a landlord's reversion falls into possession, a new period of limitation applies, starts to run, and that the tenant would be stopped from preventing the landlord from effectively engaging that provision. So Lord Scott's view was very much, this is adverse possession, and the effect of the doctrine is to limit the statutory consequences of that. The minority view, which was that of Ribeiro, was that he didn't really see how you could apply a statute only in part. That didn't make a huge amount of sense. And it's a relatively long judgment, but I think that the crux of it is at paragraph 40, in which he said, but for the intervention of the doctrine, and that's crucial, but for, an encroaching tenant who has occupied the land, encroached on for longer than the limitation period, might well be able factually to set up adverse possession as the basis for both barring his landlord's right of action to recover the land and extinguishing his landlord's title. However, the doctrine gives the landlord some protection by presuming that the tenant's occupation of the encroachment area is as an annex to his demised holding and is stopping the tenant from contending that his possession is adverse to the landlord. Now, the limitation is still important. Limitation period is still important since the doctrine is only needed and only comes into play to defeat a potential plea of adverse possession, barring the landlord's right of action after the period has run out. But he went on to say, in terms of how it actually functions in practice, that this doesn't incorporate and apply some modified version of the ordinance. What it does is it prevents the reliance on the ordinance at all. So the tenant cannot rely on the ordinance to claim a freehold title. What happens, though, is the price of that is that the landlord cannot deny the tenant's leasehold title to the encroached on land. And that's essentially, the quid pro quo for preventing the tenant from relying on the ordinance. The landlord is prevented at that point from denying the tenant's tenancy. And he puts it another way, at 64, this is the helpful passage that talks about the price being extracted by the law for such protection, is that the landlord must accept the tenant has acquired a leasehold interest over the encroachment, with possession to be recovered by the landlord only after determination of the lease. So to sum up, the majority view was the possession was adverse, the limitation runs, but there's a modified version of the statute, only a limited impact of the statute. The minority view was that expired the limitation period, but for the presumption triggers the application of the doctrine. The possession was adverse, so cannot rely on the statute at all. But the price of that is that the landlord is bound by the presumption too. Now, the interesting question is how that reasoning, which is two potentially arguable views as to how the doctrine operates in practice, would operate in the UK or in England and Wales under the Land Registration Act 2002 regime. And one must just remember, there is no limitation period in relation to registered land. That is section 96. So the tenant or the landlord can simply say to the tenant, well, you haven't acquired automatic title. The Limitation Act 1980 doesn't apply. So if you may have been in here 12 years, you may have been in here 20 years, but it doesn't give you a title against me. And therefore, how can the doctrine even be engaged? So under the majority reasoning, after 12 years, the tenant would have no rights anyway. There's no limitation period has expired. There's no statute to apply and nothing to modify, given that the Limitation Act doesn't apply. Minority reasoning, but for the presumption, the tenant would not be entitled to registration after 12 years because there's no right accrued. What about the Schedule 6? So instead of an automatic right to destroy the landlord's title and be registered in their place, Schedule 6 enables the tenant to make an application to the land registry for registration. Now, under the majority reasoning, the tenant could potentially do that. The majority reasoning said this is adverse possession. So if that were to apply, then there's no reason why the tenant couldn't apply under Schedule 6, and if successful, would have a prima facie right to be registered as proprietor of the landlord's estate. The doctrine in those circumstances, in my view, would apply to effectively limit the remedy to the tenant to an accretion to the leasehold estate. The majority reasoning is though problematic. I mean, the idea of only partially applying a statute, allowing some reliance but not full reliance, it is questionable, and it's not a good fit. At least under the old rule, one could say, well, a new period of limitation applies to the landlord when the reversion falls in, and the tenant can't deny, there's a stop from denying that the landlord has a reversionary interest in his land. But it's not a great fit. The minority reasoning is also problematic, because if the doctrine stops him from claiming he's in adverse possession at all, can he actually engage Schedule 6? The doctrine works on this but-for test. The tenant has to show that but for the doctrine, he would be entitled to be registered. But to trigger an entitlement to be registered, he can't just do it automatically. He has to engage Schedule 6, and he can only do that if he's in adverse possession. Otherwise, his application will be rejected. And only then if he can show that he's within one of the relevant gateways. Now, that's, as I say, that is problematic. Can he even do that? If he's stopped from saying he's in adverse possession, can he bring the application? Won't he simply be told, the minute he brings the application, the landlord simply defends it and says, well, you're not in adverse possession, or you can't, certainly you're in adverse possession. All the tenant has, but for the doctrine is a right he can't exercise in any event. It could be, if the minority reasoning is the appropriate one, that therefore the tenant simply cannot engage the adverse possession and the statute at all. And if that's right, then that's an end to encroachment and adverse possession. I'm not sure that is right, much as we don't have any authority on the point as to whether majority or minority reasoning applies. The other way of analysing the minority reasoning is to say that if the tenant could have engaged Schedule 6, and had he done so, he would have been registered, then he can succeed. He can engage in estoppel and get the register changed under, I think it's Schedule 4. That would only really be possible if he could show that there was an honest mistake as to boundary, because had he applied, there would be no, had he applied and the matter being dealt with under the gateway provisions in Schedule 6, he wouldn't be able to rely on an estoppel unless there was something more, in which case he wouldn't need to engage it at all. He's got no other basis for being registered, which is the second gateway. The third gateway is that he's made an honest mistake as to the boundary for the last 10 years. That one might get through. And in fact, there's a good comparison to the Section 98 defence, which says that if the landlord were to bring an action against the tenant, and the tenant could have applied under Schedule 6 and would have engaged that gateway provision, the honest mistake as to boundary, then a defence would lie. And so I think to that extent, it may well be arguable that a tenant who has made an honest mistake as to boundary for the 10-year period could engage these, could say that but for this doctrine, I could engage and these provisions and would get a right. Then the doctrine might apply in those circumstances. But there is, of course, a limit to that, which is that there's got to be an honest mistake as to boundary. And if there's been an honest mistake as to boundary, you may well find you're in the sort of Tabor and Godfrey situation. There may well be an estoppel generally, that everyone has assumed that there's that this is part and parcel of the lease, or possibly there's an estoppel by convention or representation. So you don't even need to go this far. So it may well be, if the minority reasoning is appropriate, or indeed if the majority reasoning is appropriate, that there's actually very little room at all for the operation of the doctrine of encroachment in the registered land context. The other view, which is the view expressed by some academic writers, is that the whole doctrine is nothing to do with adverse possession at all. But if that's right, you've got to jump through, you've got to satisfy some other hurdles. Firstly, there's no authority for the proposition that mere lapse of time apart from limitation gives any right. Ramsden and Dyson is absolutely clear on this. When Lord Calmer says, you know, if the tenant, unless there's a mistake by the tenant as to the extent of their title and the landlord knows of the mistake, then the estoppel is not engaged. If there's a course of dealing, if there's more, there's a course of dealing and they proceed on that common basis, then there might be an estoppel there. But you don't need to go to adverse possession or lapse of time. It's the reliance that would give rise to the rights there. As I say, the authorities we've looked at can be explained either on the basis of an estoppel. In some cases, there's some other authorities that can be explained on the basis of contract, or on the basis of classic adverse possession. But if there isn't, if this is nothing to do with adverse possession, well, where is the source of this right? What is the basis on which one says, well, after 12 years or some other period of time, the landlord becomes bound? There is no authority for it, and there's no source for that right. There's no source for that period of time. Indeed, I think the Hong Kong authority is quite illustrative of that point, because of course the limitation period in relation to the Crown was 60 years. There are different limitation periods that apply depending on the different landlord. Would that apply if there's a freestanding doctrine? Would limitation be 12 years in relation to one sort of tenant, 30 years in relation to another? And why, if this is nothing to do with adverse possession? But of course, the other argument it ignores is that it's the tenant who is estopped under Ribeiro's analysis. It's the tenant who is estopped from claiming his possession is adverse to the landlord and therefore relying on the doctrine. Why can't the landlord say, well, of course this is adverse to me. I have a right of action to recover from the tenant because he's a trespasser unless and until he establishes a right. I'm not prevented from saying this is adverse. And if I leave it and he doesn't otherwise acquire a right, at what point and why am I prevented from simply asserting this is simply adverse possession? The statute says there's no limitation period. I can bring my action, and you can't come within potentially within the Act, the 2002 Act, in those circumstances. The alternative view, therefore, I think is highly questionable and also contrary really to policy, which seems to be against promoting the idea of adverse possession, especially in the case of a deliberate land grab, where you've got registered land. I mean, the lease is likely to be well defined. The leasehold land is likely to be well defined with reference to leasehold title. Why is it that a landlord should be in a worse position than any other landowner faced with somebody occupying land outside the scope of the demise, or otherwise land that's the land held of the landlord free of any tenancy? The land registry view is not very clear, but there is one authority that I found and relied on called Skipwith and Singh from 2009, which basically treated the matter as a classic adverse possession, whether under the old Act or the new. In fact, on the fact of that case, there was a 12-year period of adverse possession established under the 1980 Act before the 2002 Act came into force. But the way the court analysed it was, you first of all look to see whether you can establish the right. The tribunal didn't have, I should say this was the adjudicator to the land registry at the time. The adjudicator held that there was nothing wrong, and in fact what had happened, they had engaged the Schedule 6 procedure. There was nothing wrong with that. It wasn't struck out on the basis that that was inappropriate. But the point being, it would have been satisfied there would have been a mistake as to title, as to boundary on the facts of that case. So the Schedule 6, had it been necessary to rely on it, would have been made out. But the effect in either case would have been the same. The tenant would only have got an accretion to their lease and not on the strict application of the LRA 2002 Schedule 6 being registered in place of the landlord in respect of the land encroached on. But this is only this is hardly a binding authority, but it's some indication that the land registry doesn't have a problem with this. I should say in my case that the judge found the same thing, although on the facts they hadn't made out their 12-year period anyway, and couldn't rely on the 2002 Act because there was no honest mistake as to boundaries. So we had them coming or going on the facts and on the law, and they weren't ultimately granted permission to appeal on the factual, given the factual findings. So I'm afraid, to an extent, the law does remain somewhat unclear, and the law of encroachment is a mess. It has been developed alongside the old law of adverse possession, essentially 12 years adverse possession with automatic extinction of title. And the Land Registration Act 2002 does not specifically deal with the problem. So quite what the law will do is debatable. Which of the analysis will be adopted is uncertain, and whether the Land Registration Act 2002 is the death knell of this doctrine or just a huge limit on it is open for further discussion in the case law. So my view is that there are risks here in the absence of a binding authority. I think the chances are it's going to be a difficult argument to run to say that there's an independent 12-year period of possession giving rise to encroachment rights. I think that is going to be a difficult argument to run in the face of the Land Registration Act 2002. But I wouldn't, in the circumstances, what I would not recommend is leaving tenants in occupation if the landlord doesn't want to accept them as a tenant of the encroached upon land. Don't give them the chance to run the argument at all and let the limitation periods expire. There is a risk, certainly, that honest mistake as to boundary could still be grounds for an encroachment argument. But beyond that, I think the chances are limited, but not so remote that they can be safely ignored. But I hope that was of some use and instructive in what is frankly a real tangle as far as the law is concerned, and an area which still provokes what may seem like rather spurious arguments and rather spurious debates in what can be rather unpleasant and often quite low value landlord and tenant disputes. But it may be nice to be able to sort of try to knock some of these things on the head, either with a factual argument at an early stage or a knockout legal argument. There is the basis for it, but there's also, I'm afraid, the basis for this to go quite a long way whilst the courts try to untangle what is a real mess. Thank you.